Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will discuss a fundamental element in understanding section 5120 of the Australian Constitution, the corporation's power. Today we will see how the High Court of Australia answers the question of what kind of laws can be enacted with respect to constitutional corporations. In my previous video we saw how the High Court of Australia characterizes a constitutional corporation. What are they? How can I know whether a particular corporation is a trading corporation or not? When dealing with section 5120, that is the first step that we need to take. In this video, however, we are taking a step further. We are asking what kinds of corporate activities can be regulated by a Commonwealth law. I want to present you with two tests that the High Court of Australia uses to ascertain whether a law is within the scope of section 5120. That is, if a law is a law with respect to constitutional corporations. So we will start our analysis now in the post-engineers era. If you want to understand the original position of the High Court of Australia, I invite you to check our video about Huddart-Parker. You can watch the video by clicking on the link in the top right corner. After more than half a century from the decision in Huddart-Parker, the High Court of Australia decided that the interpretation given by the justices in that case was too narrow. The High Court then, from a case called Strickland and Rocla Concrete Pipes, started to widen the scope of the corporation's power by reference to the kind of activities that section 5120 concerned. We have a video about this case as well. In Rocla Concrete Pipes, the High Court of Australia understood that the qualifying terms trading and financial not only concerned the types of constitutional corporations the section referred to, but also the kinds of activities that the law was to regulate. It seemed from then on that a law enacted under section 5120 extended to the regulation of the trading activities of the trading corporations. But the justices did not discuss the full ambit of that power. In the case of Actors and Announcers Equity and Fontana Films, then it became accepted that at least the power concerned the regulation and protection of the trading activities of the trading corporations. And here, two approaches came to the surface. The first, a narrow view that we could call the distinctive character test. And the second, a wider view that we can call the object of command. Let me explain these two views. Under the distinctive character test, a law will be valid if the character of the corporation as a trading or financial corporation is significant in the way the law relates to it. If the law relates to activities that are not the trading or financial activities of the trading and financial corporations respectively, then it falls outside the scope of the head of power. The power is a power to regulate the trading activities of a trading corporation, or the activities that exist for the purposes of those trading activities of a trading corporation. In this sense, section 5120 is not a plenary power over all activities of a constitutional corporation. In practice, this means that the Commonwealth law will fall within the scope of section 5120 if it regulates the trading or financial activities of the trading or financial corporations, or if it regulates other activities that are undertaken for the purposes of those constitutional trading or financial activities. This test was proposed and carried out by Chief Justice Gibbs. And I must say, this test has now been weakened by the decision of the High Court in the Work Choices case. This is not to say that this has been overruled, and some scholars even say that this test was, in some sense, still present in the majority's decision in the Work Choices case. But overall, the approach has lost its vigor. So the other test to identify whether a law is within the scope of the corporation's power is called the object of command. This test was adopted by Justice Mason. According to the object of command, section 5120 refers to a category of legal person or entity, not the activities of those corporations. The power is about persons, not activities. On this approach, any activity of a constitutional corporation could be regulated by a Commonwealth law, as long as the law singles out the constitutional corporation as the object of the law's command. As Justice Mason said in Fontana Films, The subject matter of the power is corporations, of the kind described. The power is not expressed as one with respect to the activities of corporations, let alone activities of a particular kind. A constitutional grant of power should be construed liberally and not in any narrow or pedantic fashion. In the Tasmanian Dam case, the court was split on the application of these two tests. Chief Justice Gibbs and Justices Wilson and Dawson kept on adopting the view that for a law to be a valid law with respect to a trading or financial corporation, the fact that it is a trading or financial corporation should be significant in the way in which the law relates to it. Justices Mason, Murphy and Dean adopted the object of command test, affirming that Section 5120 was a general power to make laws with respect to trading corporations. So, thus far, we did not have a favorite, majoritarian approach that the High Court used. However, in the work choices case, a majority of the courts seemingly adopted the object of command test. This seems to be the rule today, but if you want to understand a bit more about it and understand more about the work choices case, click the link appearing on your screen and check out our video about it. I'll see you there. Ciao.